All right. Dear colleagues, friends, and family, we live in a dangerous, apathic world. Confronted with unequivocal evidence about the massive destruction of the Earth's natural resources and the deep inequalities that Vice Dean was just referring to, which are entrenched in a global economic order, we continue to do law as usual. If we look at the current reality of economic globalization, it is easy to see injustice. Think of your mobile phones. The chances that they are made of cobalt and copper sourced from Congo. Congo is one of the resource-richest countries in the world, and yet, according to a study, half of the population eats only once a day. We are talking of 27 million facing severe or acute food insecurity. Or you may have read that during the first years of the COVID-19 pandemic, the world's 10 richest men more than doubled their fortunes, while the incomes of the 90% of humanity fell and over 160 million more people were forced into poverty. International trade and investment agreements, which are some of the core laws of globalization, are in many respects conducive to contemporary forms of injustice, racial discrimination, and ecological disaster. In his article, Towards a Social-Legal Theory of Indignation, Boaventura de Sousa Santos reminds us that the slogan, "We are the 99% of the Occupy Wall Street movement," resonates with no less than the words of Leo Tolstoy. In his diary in 1910, he was writing, "If a man knew nothing about the lives of people in our Christian world, and he were told, there is a certain people who have set up such a way of life that the greater part of them, 99%, live in ceaseless physical labor and oppressive needs, and the rest 1% lives in idleness and luxury. Now, if that 100 had its own religion, science and art, what would that religion, science and art be like?" I think that there can be only one answer: a perverted, a bad religion, art and science. To the list of Tolstoy, we can add a perverted law, because our own laws, particularly the laws of globalization, co-constitute the cleavage between the 1 and the 99%. These legally entrenched inequalities are coupled with the exponential looting of the Earth's natural resources. Today, we face a planetary emergency, having exceeded 5 out of 9 planetary boundaries. Laws that enable the crossing of planetary boundaries are perverted laws. To pervert comes from the Latin pervertere. Vertere stands for to turn, change course, transform, and the prefix per means through or away. So to pervert can be understood as to turn away. The perversions hinted at by Tolstoy is one by which laws, ideally aspiring to justice, turn away from it. My interest with law's perversion, however, is not rooted in nihilism. This reminds me that when drafting the research agenda for my chair on inclusive global law and governance, I was very focused on all the mechanisms of exclusion. Professor Ellen A. then told me, "But Alessandra, where is the part about inclusion?" This comment was a precious invitation to redirect my intellectual energies also on how to build inclusion. Naming and grasping law's perversion is, in my view, the preliminary step to start changing course. Pointing at the perversion of the law could be seen as the prelude to a strategy of inclusion, a first step of perverting the unjust status quo. This second turn, perverting the perverted, is the dearest to me. If for the first type of perversion I borrow the term from Tolstoy, for the second type I take cues from the writing of the very fine intellectual Nadia Tolokonnikova, well known for her participation in the Pussy Riot band and for her critique of Putin's authoritarian regime. In an epistolary exchange with Slavoj Žižek, when she was detained in a Russian prison, Nadia wrote, "We can't just reject capitalism out of hand. We'll get farther by playing with it, teasing till it's been perverted. Perverted, I mean, in the sense of being turned to face us, enlisted into our cause." For a lecture on the laws of globalization, I need to be a little bit more specific on what our cause could mean. When talking of the global, our is supposedly a rather broad subject, and the task of finding a global common cause is daunting. Let me then take a shortcut. As international lawyers, we can tap into the foundational norms of the international legal system, to be found in the 1948 Universal Declaration of Human Rights, which has been described as the conscience of the world. And the norm that comes to mind, because it directly relates to the international order, is Article 20A, establishing that everyone, let me emphasize, everyone, is entitled to a social and international order in which human rights can be fully realized. So, establishing an international legal order where everyone's human rights are fully realized can plausibly be considered a common cause of the international legal order, of us, international lawyers. Against this background, I ask, how can we pervert or enlist into our cause the perverted law? To answer this question, we first need to understand how perverted law is normalized. Next to violence, an important stumbling block for transformative change is the construction of narratives sustaining the unjust laws. What this narrative do can be likened to the basic tricks of magicians called misdirection. You may all have been exposed to this trick once in your life. The magician who is playing the trick typically tells you a story whose main aim is to divert attention from a significant action to an insignificant one. Dominant narratives do the same. The power of the narrative is not only in what it asserts, it is also in what it obscures. Think of terra nullius or the standards of civilization. These are legal narratives ingeniously constructed by international lawyers to divert attention from the core business of colonialism, exploitation, and extractivism. Among the contemporary laws shaping globalization, international investment treaties are possibly the most appalling for reproducing a colonial logic and ensuring the normalization of exploitative, earth-damaging human relations. Somewhat oversimplifying, for those of you who have never heard of investment treaties, these treaties endow foreign investors with the right to initiate international arbitration against the state where they invest, what goes under the name of ISDS. Investors can bypass domestic courts and resort to three arbitrators who are not judges, but lawyers often working both as legal counsels and arbitrators, giving rise to serious conflict of interest. Foreign investors have unscrupulously deployed the system, launching disputes with great potential of curbing public interest regulation. Infamous cases include Philip Morris versus Australia and Uruguay, in which the company has harassed these countries for their tobacco regulation. And if you want to know more, check the hilarious episode of John Oliver on tobacco, or Chevron versus Ecuador. As well recounted by Lorenzo Pellegrini and other colleagues, Texaco Chevron spilled 16.8 million gallons of crude oil in the Amazon, destroying pristine natural environment and making miserable the life of indigenous communities. When after 27 years of legal struggles, the communities of the Amazon obtained damages before an Ecuadorian court, Chevron has deployed the arbitration system to render this ruling unenforceable. The list of instances in which the polluting activities of extractive industry have been protected through ISDS is long and sad. Let me just add a few words on a case which has been decided only last week and is particularly dear to me because I've been studying for the last year. The case was lodged against Italy by the UK company Rockhopper, whose chief business is extracting gas and oil in the Falklands Islands and Italy. In 2014, Rockhopper bought the company Medoil, which obtained a permit for offshore exploration to search for oil in the beautiful Adriatic Sea. At that time, it was clear that the local communities did not welcome the project. In fact, the region resisted oil extractivist projects already from the 70s. I visited the place last October and could hear from the people in Abruzzo how shocked they were when they saw a jackup rig towering the sea in front of their coast. The 2010 Deepwater Horizon oil spill in the Gulf of Mexico, the largest marine environmental disaster related to oil spills in history, brought to public attention the dangers of offshore drilling. In reaction to this disaster, the Italian government adopted a law decree prohibiting the extraction of oil within 12 nautical miles from the coast. This meant a halt to the project, as the jackup rig was positioned just within this distance. Yet, after successful lobbying by the oil corporation, an exception to the 2010 law was made so that Medoil project could have, in theory, proceeded. Yet, massive opposition by the civil society led the government in 2016 to clarify the law so that no exception for the Rockhopper project could have been made. Offshore drilling near the coast in Abruzzo was definitely outlawed. When Rockhopper bought Medoil, in 2014, there was only an exploratory permit. No permit for initiating drilling was ever issued. Rockhopper should have known that the Abruzzo region had chosen for a non-oil-driven developmental model. Rockhopper should have known that the community of scientists had denounced the toxic effects of oil extractivist projects. Rockhopper probably knew that winning in an Italian court was highly unlikely, because under Italian and European Union law, you have no right to pollute and no expectation to profit can accrue from just an exploratory permit. But Rockhopper also knew that he could rely on ISDS under the Energy Charter Treaty. Rockhopper, which invested allegedly 40 million, has been awarded, just last week we know, $190 million plus interest, so this makes 250 million in compensation. The case was funded by a third party, costing zero to Rockhopper. When all the science tells us that we should keep fossil fuels under the ground, Rockhopper can invest in generous compensation in new extractive projects in the Falklands. All right, so the attentive listener may remember that I left the question lingering: how to pervert the perverted law? A preparatory exercise to transformative change, in my view, is to change the narratives. In this lecture, I want to talk you through two typologies of narratives in law: justificatory and constitutive. The justificatory narratives are deployed to legitimize certain rules, which otherwise would be hard to pass. For example, the exceptional rights for investors established under investment treaties are not normal and needed some form of justifications. They are a deviation from standard international law. So two dominant narratives have been used to this end. The first is that investment treaties bring about development, and the second is that they foster the rule of law. In the research conducted with my colleague Federica Violi, we have deconstructed both narratives, showing that there is no evidence that investment treaties bring about development, and that only an Orwellian understanding of the rule of law, where some animals are more equal than others, can be deployed to justify the system. But I want to talk you through the narrative constitutive of law. When rules are open, which is often the case in law, narratives can also constitute law. To continue with the example of investment treaties, think of the standard of fair and equitable treatment, according to which the foreign investor should be treated fairly, or the rule prohibiting indirect expropriation without compensation. These rules are related to the doctrine of legitimate expectation, which has been invoked by investors in virtually all ISDS cases. While tribunals have differed One notable narrative underpinning this doctrine is that it is reasonable for investors to expect a stable regulatory environment. Let's go back to Rockoper versus Italy. Oversimplifying somewhat, this may mean that investors can obtain compensation if the regulatory environment changes from being first encouraging of oil-driven economy to one prioritizing people's right to a clean and healthy environment. The narrative of regulatory coherence informs the legal doctrine of legitimate expectation, as well as the interpretation of the rule on indirect expropriation. Remember the magician trick? This narrative is powerful for what it obscures. So understood, the narrative of regulatory coherence erases democracy. The Rockoper Award is not public yet, and it is premature to comment. But in the past year, I studied how the Italian government reached the decision to outlaw offshore drilling. In this work, I've shown how rational ecological regulation is entangled with democratic processes, and sound environmental regulation is often the outcome of civil society resistance and struggle. By obscuring the role of democracy for achieving rational ecological regulation, this narrative, contrary to what good sense would dictate, magically transforms the expectations to pollute and exploit into legitimate expectations. But expectations to profit from the making of sacrificial zones are not and should not be legitimate under international law. My analysis denouncing the fraught nature of certain narratives constitutive of law, such as the one about regulatory coherence, is inspired and draws on a notable body of scholarship. I can only briefly mention the work that has exposed how investment treaties can be systematically deployed against the energy transition. In this context, it has been estimated that future fossil fuel cases could generate 340 billion in legal claims. There is also rich scholarship situated in the traditions of third world approaches to international law and political economy, which has convincingly demonstrated that what it appears to be the spectre of racial capitalism in investment treaty law is not a spectre at all. It is racial capitalism by design. This work of perversion is a prelude to change, a micro-revolution necessary to pervert the perverted law. The fact that the Intergovernmental Panel on Climate Change in its 2022 report discusses the chilling effects of the Energy Charter Treaty on climate action may be a sign that micro-revolutions are producing some effects. Another sign may come from the complaint lodged before the European Court of Human Rights on June 21, 2022, by 5 young individuals against 12 European states for the membership of the Energy Charter Treaty. The applicants claim that the government's participation in this treaty violates their human rights. This type of cases bear witness to the possibility of reimagining the law as just. Now, I know that a lot of you are already longing for the Bitterballen, but you have to bear with me a little longer. I want to go to talk you to another example. So let me move to a different realm on the laws of globalization, international trade law. And with this system, zoom in on the regime of intellectual property rights. This realm is illustrative of how certain market narratives are not just dominant narratives, but narratives of domination. For those of you not familiar with the jargon, intellectual property rights refer to patents, copyrights, trademarks, trade secrets, and the like. And the key agreement is the agreement on trade-related aspects of intellectual property rights known as TRIPS. TRIPS has transformed, back in 1994, Western regimes of intellectual property rights into a global regime. Many of you may have heard of this agreement in the context of the COVID crisis and the difficulties of vaccinating the entire world population. In the context of this crisis, the profits made by the main corporations producing COVID-19 vaccines have been extraordinary. For example, Pfizer has earned more than $81 billion in 2021, doubling its earnings of 2019, which were about $41 billion. Such extraordinary profits have been made while a large part of the world population has not been able to afford vaccines. The biggest winners of the COVID-19 pandemic, Pfizer, BioNTech, and Moderna, have sold the overwhelming majority of vaccines to high-income countries. According to one estimate, for every 100 people in high-income countries, 133 doses of COVID vaccine have been administered, while in low-income countries, only 4 doses per 100 people have been administered. In August 2021, vaccine inequality was extreme, with approximately 60% of the European and American vaccinated, whereas only 3.1% of the people in Africa continent was. If an alien would witness this extraordinary disparity from the distance and would ask, what type of law is the one that made all this possible? What would be the answer? Slightly paraphrasing Tolstoy, I think that there can be only one answer, a perverted law. Already in October 2020, India and South Africa, supported by other 60 countries, proposed a TRIPS waiver. That is the adoption of a temporary exception that would have waived virtually all intellectual property rights related to health, products and technologies necessary for the prevention, treatment or containment of COVID-19. In view of many, the waiver would have facilitated the production of COVID-19 therapeutics on a worldwide scale by reducing the costs created by various intellectual property rights. But the proposed waiver has been strenuously antagonized by the EU, Switzerland, and other Western countries. How is it possible that before such stark injustice, the EU, always bragging about European values, has been so fixated in obstructing the waiver? The TRIPS agreement is a perfect illustration of how perversion can be rooted in the dominant narrative. In fact, I'm sure that while I was mentioning the waiver, some of you may have thought, wait a second, the EU has a point. Intellectual property rights are necessary because they stimulate innovation. This is precisely the main narrative Big Pharma and the EU deployed to oppose the TRIPS waiver. The dominant narrative for justifying the adoption of the TRIPS agreement goes like this. I know my law and economics friends are getting nervous, but wait. Ideas, information and knowledge underpinning the development of therapeutics can be understood as goods from which others cannot be excluded. Non-excludability means that other market actors can free ride on the producer of such knowledge, leading to what economists call market failures. This in turn implies that innovators will lack sufficient incentives to continue to produce valuable knowledge. In the case of COVID, it has been argued that without the existing patent system, we would not have had enough incentives to produce the vaccine. By allocating property rights on intangible knowledge, intellectual property law enables innovation. This narrative is the justificatory narrative in one of the WTO staff paper, so an official paper, explaining the economics of the TRIPS agreement. The case of TRIPS is particularly interesting because the narrative is incoherent with its own internal neoclassical economic logic. And here my law and economics friend maybe are relaxing a little bit. The problem is that the dominant narrative glaringly glosses over the monopoly bestowed by intellectual property rights on the companies and the market power that derives from it, especially in case of essential medicines for which demand is typically inelastic. Why, when creating rules establishing de facto monopolies, have we not enacted rules to control the ensuing market power? In fact, the embedding of the regime of intellectual property in the trade regime has been criticized by economists since its origin. So we are talking of more than 20 years ago. You don't need to be a Crete to understand why. This is Economics 101. Well-known mainstream international trade economist Jagdish Bhagwati wrote about it almost 20 years ago in his book In Defense of Globalization. And I quote, "TRIPS were introduced into the WTO integrally. TRIPS were like the introduction of cancer cells into a healthy body. For virtually the first time, the corporate lobbies in pharmaceuticals and software had formed an important multilateral institution, turning it away from its trade mission and rationale and transforming it into a royalty collection agency." Against this backdrop, how is it possible that Big Pharma and the EU Commission have continued to reproduce the dominant narrative to defend the globalization of Western intellectual property rights? One explanation is that the narrative of the private enterprise as innovator and in need of protection has been powerful in creating and further legitimizing this regime. You see misdirection at play? In directing our attention to market failures, the narrative implicitly relegates public authority to a residual role. Governments cannot best fix the market. Our attention goes to the private enterprise as the main actor of innovation. But this is a mystification of reality, or the magician trick of misdirection. As Mariana Mazzucato has cogently demonstrated in her work on the entrepreneurial state, states have played a pivotal role for innovation. For example, fundamental innovations such as the Internet, GPS, touchscreen displays, and I see my kids that are all happy with this innovation, were all developed predominantly by public entities. As you may have read in newspaper, most companies selling COVID-19 vaccines have received generous public funding. According to one estimate, the US federal government spent between 18 billion and 23 billion to develop all the COVID vaccines. To this, it should be added that research on mRNA technology, the technology at the basis of the most successful vaccines, has been conducted by publicly funded science since the early 90s. But don't think this is specific to COVID-19 vaccine. A 2018 study has demonstrated that the US National Institute of Health financed research was associated with every one of the 2010 drugs approved by the FDA between 2010 and 16. Already in 1944, Karl Polanyi offered a magisterial analysis of the market as a creature of public authority, rather than a natural phenomenon. The so-called market economy, as we know it today, depends on the rules allocating and protecting of property rights, on the laws enforcing contracts, on the existence of the police, and so on and so forth. The distribution of legal entitlements is what co-constitutes markets. And yet, here comes the magician trick. What we should have known is eclipsed by the market failure narrative. The narrative has diverted our attention from the pivotal role played by governments and let us naturalize the idea that innovation is all driven by private enterprise. If the main narrative distracts us from reflecting on how public authority is in the driver's seat when it comes to innovation, it also distracts us from the interconnected question of value. It normalized the idea that market prices are the best proxy for value. When thinking of medical products, for example, the higher the price, the more valuable the medicine, or so the argument goes. Research of the pharmaceutical sector, by contrast, has brought to light how the monopoly rents extracted through high medicine prices are used to buy back shares, boosting profits for shareholders and senior executives rather than being invested in innovation. Buybacks is a way to manipulate the value of the shares, increasing them and rewarding sellers of shares. To give you a number, over the decade, I'm quoting, 2005-2014, Johnson & Johnson, Pfizer, and Merck The three largest pharma companies spent an annual average of 3.9 billion, 6.1 billion, and 2.6 billion, respectively, on buybacks. These numbers are Exhibit A, that high prices aren't necessarily correlated with public value. They rather look like as extractivist practices through which wealth is taken from society at large for the benefit of the shareholders and corporate executives. Regrettably, this kind of thinking has treated prices as surrogate of societal values, obscuring the real dynamics underpinning price formation. The figures on the profit of big pharma are illuminating in these regards. It was reported by a study published in 2022 in the British Medical Journal. From 1954 to 1999, the drugs industry mean profit margin was already more than double the average of other sectors. Since the turn of the century, this has ballooned to more than triple. While the cost of manufacturing a Pfizer-BioNTech vaccine dose have been estimated to be around $3, the price per dose paid by the EU has reached $9.5 and by Israel $28. As the dominant narrative started to crack under this body of evidence and indignation mounted, the EU Commission, trying to defend its opposition to the waiver by arguing that waiving patent was not a solution because of various other reasons. Echoing the pharmaceutical industry, Ursula von der Leyen, for example, was tweeting on June 9, 2021, that vaccine production requires know-how, technology, skilled personnel, and infrastructure. You don't get there by simply waiving IP rights. A study by the Imperial College London has demonstrated that injectable medicines manufacturers can adapt and start producing mRNA vaccines in relatively short time. Building on this work, researchers at Doctors Without Borders identified 120 manufacturing facilities capable of producing mRNA vaccines in low and medium-income countries. Sure, you would also need technology transfer. But a technology transfer could have been mandated by Western states on their corporations. In fact, the very text of the TRIPS agreement establishes that developed countries shall provide incentives to enterprises and institutions in their territories for the purpose of promoting and encouraging technology transfer to least developed countries. Arguably, in a pandemic, technology transfer could have been directed also to manufacturing companies of developing countries. This would have been a sound reading of the TRIPS agreement when considering its objectives, spelled out in Article 7, which read, the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technologies to the mutual advantages of producers and users of technological knowledge, and so on and so forth. Mandating transfer of technology would have contributed to realize the fundamental values of Article 28. And there is more. In May 2021, the Director General of the WHO has characterized the state of affairs around the COVID-19 vaccines distribution as one of vaccine apartheid. In this context, he has also reminded us that in the case of HIV, it took 10 years before antiretroviral drugs reached low-income countries. In March 2022, a consortium of civil society organizations from the Global North and the Global South has submitted an appeal before the United Nations Committee on the Elimination of Racial Discrimination under its early warning and urgent appeal procedure against the government of Germany, Switzerland, the UK, and the US for, among others, their opposition to a comprehensive TRIPS waiver. In its statement concluding the procedure, the UN Committee reiterates, and I quote, its call on state parties to combat the COVID-19 pandemic guided by the principle of international solidarity through international assistance and cooperation, including by supporting the proposal of a comprehensive temporary waiver of the provisions of the TRIPS agreement. In the same statement, the committee referred to the unequal access to vaccines as replicating, and I quote, slavery and colonial-era racial hierarchies. Echoing this, on June 14, the UN Special Rapporteur on Contemporary Forms of Racism, Tendai Akume, submitted an open letter to the WTO Ministerial Conference, urging the members to adopt a comprehensive COVID-19 waiver. She explained that, and I quote, a failure to authorize a comprehensive waiver would run counter to the fundamental human rights principles of racial equality and non-discrimination. As we have seen earlier, the dominant narrative placing corporations at the center of innovative processes in an allegedly free market obscures the role of the states and the political nature of markets. The UN Committee and the Special Rapporteur are disrupting in at least two other ways the dominant narrative. First, they place the economic order within an historical context, linking the existing inequalities to the colonial past. The dense and intense web of intellectual property rights imposed on a global scale through WTO law ensures continuity with the colonial past. Second, under the dominant narrative, human rights were backstaged, treated as a marginal appendix to the economic system. The UN Committee and the Special Rapporteur are asserting the centrality of human rights in the economic system. This, in my view, is one of the most important narrative shifts for perverting the laws of globalization. It is a question that I've thematized in my previous work, where I denounced the perversion of the legal construction of an economic sphere as divorced from politics and ecology. In continuing to associate the economy with some artificial construction of value, typically reduced to GDP's growth and the like, we lose sight of the fact that the economy is constituted by oikos, the house, the dwelling, and nomos, the ruling of. Regrettably, under our current system, the oikos has been erased. We, the people, are being evicted from our house, the planet, by totalizing legal narratives protecting capital for the sake of its own reproduction. The dramatic disconnect between oikos and nomos has been beautifully captured by philosopher Michael Marder in his book Energy Dreams, and I quote him because I find this text very poetic. Once economy is mutilated as the anomic nomos bereft of oikos, the universal relations of value take over this absent, spatial, embedded, singular milieu and put everything and everyone as everything, to work for the same extraneous ends without end of a self-expanding potentiality. As international lawyers, we need to look at the emancipatory ways through which the oikos and the nomos could be reconnected. Okay, let me now get back down to earth. Almost 2 years of negotiations on the TRIPS waiver and the strenuous opposition of the EU, Switzerland, and other Western countries. After these 2 years, WTO members have met again on June 17, 2022, and agreed to a temporary TRIPS waiver. However, this is an emasculated version of the original proposal. The TRIPS waiver, as originally proposed, demanded waiving virtually all the intellectual property rights protected by TRIPS, including patents, trade secrets, and targeted all health products and technologies. Regrettably, the adopted waiver is less comprehensive than what was urged by the UN Committee and the Special Rapporteur, as it applies only to patents on COVID vaccines and only to a limited set of countries. One problem with this narrow scope is that trade secrets can still be deployed to block the development of vaccines in low and middle-income countries. In fact, the technology to produce mRNA vaccines is amply protected not only by patents, but also through trade secrets. Despite the efforts of the WHO to set up a transfer technology hub, no vaccine producer has shared the technology to produce vaccines. The adopted waiver is also limited because of its narrow coverage on vaccines, as if other therapeutics are not relevant to address the COVID crisis. These are the remains of the TRIPS waiver, achieving too little, too late. As you can see, we are not quite there. At this point, you can think, but where is the hope in all of this? What is the purpose of perverting the narrative when the effects are so dismal? Rebecca Solnit's book, Hope in the Dark, offers an encouraging answer to the metaphor of mushrooming. And I quote her, "After a rain, mushrooms appear on the surface of the earth, as if from nowhere. Many do so from a sometimes vast underground fungus that remain invisible and largely unknown. What we call mushrooms, mycologists call the sprouting body of the larger, less visible fungus. Uprisings and revolutions are often considered to be spontaneous, but less visible long-term organizing and groundwork or underground work often lay the foundation. Changes in ideas and values also result from work done by writers, scholars, public intellectuals, social activists, and participants in the social media. It seems insignificant or peripheral until the very different outcomes emerge from transformed assumptions about who and what matters, who should be heard and believed, who has rights. And this brings me to my last point, finally, a self-reflection on the role of academic lawyers. When we come to realize through our studies the dynamics of injustice pervading our laws, it is imperative to denounce them and to offer emancipatory narratives to reconstitute the law. In the two examples I discussed today, I hinted at how law could be reimagined. For instance, the doctrine of legitimate expectations can be radically rearticulated so that investors should learn to expect regulatory ruptures necessary for urgently needed environmental action. Or in the case of TRIPS, we can reconstitute the law by foregrounding the role of technology transfer enshrined already in the treaty text. Or, hinting at my future research agenda, we can look into the potential systemic role to be played by national security exceptions for public health and environmental emergency. However, when we see that an epistemic community, such as the one of international arbitrators, is deaf to our arguments, we should put our epistemic authority at the service of the struggles of the civil society, such as the one for abolishing the Energy Charter Treaty. This is what, together with many other colleagues, I have tried to do, for example, writing open letters, talking with policymakers and high-ranking officials in the Dutch Parliament, in Brussels. For engaging with the civil society, some colleagues have been criticized as not neutral and have been disparagingly labeled as activists. We should be reminded then that the lack of action equates omission, which in law can amount to criminal conduct. Not to act against unjust laws is an act of omission or complicity. Advocating for engaged or activist scholarship does not detract from the importance of perverting the narratives in our teaching rooms and scholarly writings, even if the effects of this gentle act of perversion are not immediately felt. After all, the practicing lawyers shaping legal doctrines are the products of our own law schools. And I was reminded of this responsibility by the reference to the words of Victor Hugo, and yes, Fabian, I am a cinephile, in the beautiful 2019 film Les Misérables. And if my French allow, I quote, "Mes amis, retenez ceci, il n'y a ni mauvais herbe, ni mauvais homme, il n'y a que des mauvais cultivateurs."